number 1 case serial number 35, BA number 3300/2026.
Serial number 35. The learned counsel for the petitioner seeks permission to withdraw this bail application. This bail application is dismissed as before.
From daily case case item 4 contains civil table 19 of 2025.
I can't hear you.
This matter is posted on Thursday, earlier for respondent ESIC. So, was to remand due Tuesday. Due to personal difficulties, my senior has to argue.
Which matter?
Number we see 4354
You
disposal.
are mentioning it outside the list.
Yes.
What do you want?
Thursday listed. And Tuesday.
Yesterday, sir.
Thursday.
थर्सडे की बजाय ट्यूसडे को करना चाहते हैं. इसके लिए आईए फाइल करना पड़ेगा, ऐसे नहीं होगा. When there is a judicial order, it can be modified only through an IE.
Madam, Schedule 4 without use order comply.
This order has been
This matter was listed last Thursday. Asked them to file an affidavit. They filed an affidavit.
What is it, madam? Settlement issue order had been complied.
It has not been complied with.
But order was also
Yes, what is it? What is happening in an individual case? What is your show cause? What show cause are you filing?
See, may recapitulate that earlier they used to file the affidavit that they are in the process of compliance. They are having meeting on several dates in January, February. University was monitoring.
after finally decided.
Let me complete. University was monitoring this matter on monthly occasion. Now, on each and every occasion, they were taking different stands. Earlier, they have said that we have to create a shadow post. Thereafter, they have said that the character is in legislative election university. Now, university, on the last occasion, they have said that in the entire state of Jharkhand, there are several matters. So, university has said that you simply take the decision in the matter of petitioners. Now, today, university, they have served me a copy. And they have rejected my claim on a completely frivolous ground on saying that the similar matter on which the petitioner is seeking parity, the said stood affirmed up to the Honorable Supreme Court, and the LPA has dismissed only on the ground of limitation. So I will not take parity from that matter. ये तो LPA limitation में हो गया तो बोलना नहीं.
ये जो अपील है, right? ये जो writ का order है, it has become final.
It has not been asserted.
Once it has not been interfered, you have to comply with this order.
Lordship, can we see the
Yes.
last?
Para 12 से पढ़ेंगे.
Para 11 would be.
Para 11 से पढ़ेंगे.
Yes, yes. At this learned counsel for the petitioner has relied upon the judgment passed in this case by this court in WPS number 5151 of 2016 and 16/9/2023. I am pausing for a moment, Your Lordship. This petitioner of 5151 of 2016 is the person whose names figure in the same communication letter, government communication letter by which my services stood confirmed and in terms of the judgment passed by our Supreme Court. While observing several relevant portions, Your Lordship has even quoted that in the impugned order, in the order under offence at page number 11, the absorption letter is also quoted. Now against this writ petition, they have preferred an LPA that is to dismissed. Now they are taking against that they have preferred SLP that also dismissed, Your Lordship. Now in their recent order they are saying that since the LPA has been dismissed on the ground of limitation, so parity cannot be.
LP against which order has?
5151 of 2016, not against my order, Your Lordship. 5151.
So the LPA has been dismissed.
Yes.
And they have given the benefit so far as the petitioner of
Yes,
5151 is
Your Lordship.
concerned.
SLP is also dismissed, Your Lordship.
SLP is also
Yes, Your
dismissed.
Lordship.
So your case is of parity.
Yes.
Once you give the benefit to this particular
Yes,
person,
yes.
you cannot deny the benefit to that.
Because I am also a retired employee and
That's right.
thereafter, Your Lordship, and also judgment dated so and so, The land council further submit that the benefits arising of the judgment dated so and so has been confirmed. इसको भी thereafter Yashoda Devi Your Lordship, she has also been given the same benefit. Your Lordship has
Yashoda
taken-
Devi has also got the same benefit.
Yes, Your Lordship, entire benefits. And respondents by letter dated so and so by the Director Higher Education, the Land Council has also relied upon the judgment passed in 4833 of C has also been given, Your Lordship, 4833 of 2000. There were three petitioners, Trilochan Mahato, Vanna, and Vijay Lakshmi. They have been given the entire benefits, including current pension, Your Lordship. One of them has also died because I was also one of the petitioners there in Your Lordship. And submitted that the name of the petitioner in the said case was also not approved. The issue is they have taken in the counter affidavit that they are time and again saying that the name of this petitioner was not figuring in Justice Agarwal Commission. Now, Your Lordship, pausing for a moment, just I would be saying, Your Lordship, that once Your Lordship has taken note of the fact that it is spite of the fact that the name of the petitioners of those cases were not figuring in Justice Agarwal Commission, even then you have given the benefit. Now, since the petitioner he is also from the same absorption letter, pursuant to their Your Lordship,
Okay, fine.
report, but the order passed by this court has ultimately been complied in contempt case number so and so. The land council for the petitioner respondent cannot treat different person differently and petitioner is entitled to be treated at par with other similarly situated persons. After hearing the land council to parties and considering the facts and circumstances of this case, this court is of the considered view that different orders have been passed by this court in connection with entitlement of one or the other persons taking into
Now you
consideration.
just responding, you have rejected that claim, right? The order was passed primarily on parity, correct? So you have given benefit to this Yashoda Devi and others. How is their case different from Yashoda Devi and two others? Have you discussed it, that how is their case different from Yashoda Devi and others? Let us see.
But Yashoda Devi का नहीं डिस्कस किया।
51 का clear.
Council kindly see.
दो तीन लोग हैं ना, तीन रेट पिटीशन का नंबर है, राइट? तो तीनों को कहाँ है डिस्कशन? And how is their case different? How is the case of the petitioner different from other similarly situated cases?
उसका वो लोग लिखे। Council kindly
हाँ,
see.
पढ़िए, कहाँ लिखे?
The region order.
हाँ,
Lecture 8 page 12.
हाँ, ये नंबर 3 में देखिए,
13 में।
पैरा नंबर 3, पेज नंबर 13, पढ़िए, क्या बोले हैं आप?
13 में। उक्त के आलोक में मामले की समीक्षा की गई एवं निम्नलिखित तथ्य पाए गए। फर्स्ट, बीएन कॉलेज सिसई के पत्रांक सो एंड सो डेटेड सो एंड सो द्वारा वादी की नियुक्ति क्लर्क के पद पर की गई, जिस पर वादी द्वारा दिनांक 4/1/1985 को योगदान दिया गया। वादी का नाम सरकार के पत्रांक
नहीं, आप हमको वो यशोदा वाला खाली दिखाइए, कहाँ लिखे हैं?
यशोदा वाला बाय नेम से नहीं हुजूर, बट
रीट
लास्ट
का नंबर है ना, WPS, हाँ पढ़िए, WPS नंबर
WPS 481/2000।
5151 would be precisely exactly इन्हीं का है, उसी सेम ऑब्जर्व 5151 के बारे में पूछ लिया जाए।
5151 के बारे में कहाँ लिखे हैं?
हाँ, उसके बाद
हाँ, ये वाला वो जो लिखे हैं
कहाँ है?
जहाँ पे WPS नंबर सो एंड सो वादी का संबंध है।
सो एंड सो मत बोलिए, कहाँ पर है?
पेज 14 में माइलम।
पेज 14,
पेज 14 माइलम।
हाँ पढ़िए,
यहाँ से हम पढ़ रहे हैं।
WPS नंबर,
WPS नंबर 1244
हाँ, हाँ।
2023 दिनेश साहू वर्सेस सो एंड सो
हाँ,
के न्यायाधीश में माननीय उच्च न्यायालय द्वारा WPS 5151/2016 डेटेड 18/9/2023 के न्यायाधीश का उल्लेख किया गया है। इस संबंध में उल्लेखनीय है कि माननीय उच्च न्यायालय के आदेश के विरुद्ध सरकार द्वारा अपील दायर किया गया था, जो माननीय उच्च न्यायालय एवं माननीय सर्वोच्च न्यायालय द्वारा निरस्त कर दिया गया।
तो
उक्त अपील आगे उठो,
तो ये कोई डिस्टिंग्विशिंग फैक्टर है?
आगे आगे हम
नहीं, यहीं पे रुकिए ना। How is the case of the petitioner different from WPS number 5151 of 2016?
आगे हम
पढ़ाइए आगे क्या है?
आगे हम अपील मेरिट के आधार पर नहीं बल्कि विलंब से अपील दायर किए जाने के कारण इसे स्वीकृत किया गया था। उक्त बाद के वादी का वेतन निर्धारण किया गया।
स्वीकृत किया गया।
उसके बाद WPS नंबर 481/2021 वादी का वेतन निर्धारण तो किया गया था, पुनः वेतन निर्धारण के पुनर्समीक्षा उपरांत वादी का नाम माननीय अग्रवाल कमीशन एवं माननीय सिन्हा
फिर
कमीशन।
वही पहुंच गए. I just want to know how is the case of petitioner, apart from whatever you have written over here, is different from the case of WPS number 5151 of 2016. How is it different?
डिफरेंटली आगे में
स्टेट का तो यही धंधा ही है, सब अपील बिलेटेड फाइल करिए, उसके बाद सारा अपील डिसमिस करा दीजिए, उसके बाद everybody is entitled to a parity. You are responsible for delayed filing of appeal and SLP. पैसा भी क्यों बर्बाद करते हैं फाइल करके? There is no reason. Just tell us from this order how is the case of the petitioner different from the petitioner of WPS number 5151 of 2016.
ये चीज तो आगे वो लोग
आगे से क्या मतलब है, यहीं पे बताइए आप. How is the case different? Who is OP number 2? क्या नाम है आपका? हाँ आप ही बताइए, आपको इसीलिए बुलाएं. WPS नंबर 5151 ऑफ 2016 के पिटिशनर से इनका केस कैसे अलग है? एंड इफ यू आर नॉट एबल टू डिस्टिंग्विश, इस ऑर्डर में तो नहीं लिखे हैं SLP डिसमिस हो गया लिमिटेशन पर, ये कोई डिस्टिंक्शन है? इज इट अ डिस्टिंक्शन? एक ही है तो आप दीजिए, एक को दिए दूसरों को भी दीजिए.
50,000 कॉस्ट हुआ था उस इसमें 5151 में.
Heard the learned counsels appearing on behalf of the parties. OP number 2 नाम बताइए इनका. सूर्य सुधीर बारा is present in the court. A supplementary show cause has been filed annexing there a reasoned order dated 6/5/2026. During the court proceedings, a specific query was put by the court as to how the case of the petitioner is different from WPS number 5151 of 2016, whose reference has also been mentioned in the writ petition being WPS number 1244 of 2023, with respect to which the contempt proceedings have been filed on account of non-compliance. On perusal of the order, it is apparent that no distinction except that the appeal arising out of the order passed in WPS number 5151 of 2016 was dismissed, has been mentioned in the reasoned order. Upon a query of this court, the opposite party number 2 has submitted that on facts there is no distinction between the case of the petitioner and the petitioner of WPS number 5151 of 2016. In such circumstances, this reasoned order is just an eyewash, and the order of this court has not been complied with in letter and spirit. क्या करना है आपको? सप्लीमेंट्री शो कॉज फाइल करना है? क्या करना है? The learned address the learned counsel for the state upon instruction from OP number 2. Upon instruction from OP number 2 has submitted that they shall file a supplementary show cause and a fresh reasoned order will be passed, taking into consideration the parity between the petitioner and the present petitioner and the petitioner of WPS number 5151 of 2016. कितना टाइम चाहिए? 8 वीक में कितना क्या करना है आपको? 8 You see, आपको भी रिटायर होना है ना लाइफ में, ऐसा नहीं करना है। अगर स्टेट इतना कॉन्शियस है कि भाई ऑर्डर गलत हो गया कोर्ट का, तो टाइम से अपील भी तो फाइल करना चाहिए ना। एक को दिए हैं, दूसरे को, दोनों पड़ोसी हैं, एक को 10,000 रुपये मिलेगा महीना और एक को 15,000 रुपये महीना मिलेगा पोस्ट रिटायरमेंट बेनिफिट्स, ठीक है ये? कब रख दें? 10 जुलाई हो गया ना, एक वीक। आठ वीक से ज्यादा हो गया। Post this case on 10th of July 2026. The supplementary show cause be filed by 7th of July. There can be no reason for the opposite party to refuse to give the same benefit to the petitioner as has been granted to the petitioner of WPS number 5151 of 2016.
From supplementary list, we mention case item 1 CMP 847 of 2022.
डेट और केस नंबर
क्या नंबर होना चाहिए?
18/9/22
कितना होना चाहिए? 22/9/22 लिखिए।
और
CMP number 847 of 2022. This case has been listed at the instance of the office by indicating that there is an inadvertent error in paragraph 2 and paragraph 5, wherein the order date wherein the date of order passed in WPS number 3233 of 2022 has been mentioned as 18/9/2022, whereas it ought to have been 22/9/2022. Peruse the record. The order dated 1/5/2022 passed in CMP number 847 of 2022 is modified to the extent that in paragraph 2 and 5, the words 18/9/2022 be read as 22/9/2022. The office is directed to carry out necessary conditions. 2 and 5 दोनों करती हैं।
Orders item 2 CMP file number 14412 of 2025.
Restoration. Defective.
डिफेक्टिव
Petitioner absent. Time till 12th of June is granted to the petitioner to remove the surviving defects preemptively. Oh, ये दो first appeal filing number
327/2020. But in the status is not saying that it's a dismissed for default.
status is not shown.
Because it has been taken on first appeal 327 filing number in which your ladyship has ordered to pay the court fees.
Okay. But it is not a preemptive order.
That was the preemptive order on 17th March 2026. But this CMP has been filed against the dismissal default for 6th November order.
Maybe they want to amend it. ये CMP में लिखिए। Petitioner absent. Post on 12th of June by way of last indictments.
20
Preemptive कुछ हो सकता है, उनको कुछ amendment करना पड़े उसमें।
Offense filing item 3, DA.09.08.5 of 2026.
Case number 20. Case number 30 is the order.
29.
29.
So what is the fresh ground? इतना recent है rejection.
There are two phase rounds. First is a phase rounds. First, कोई कुछ persons have been granted anticipatory bail. Number one, number two, charge sheet has been made. Your lordship, see your lordship order passed the lordship, then it was rejected at that stage. Specific taking note that at the time charge sheet was not submitted. If you permit to para file.
Anticipatory bail कब मिला?
इसके बाद मिला.
कहाँ है anticipatory bail का order?
Annexure 3 is 23. Usually it's simple. 400 persons have fight for a pond, for construction of a pond. Two groups, there are case and counter case. Two groups have fought for a construction of a pond, and for which 400 to several persons have made it. There is no specific allegation, injury is simple.
From where do I get that the injury is simple?
Into order. Para 6. Case 33, report annexed with the case diary, so simple in nature by 100%. Case 33.
What do you say? Yes? State. Okay. चार्जशीट हो गया, आप क्या केस डालेंगे?
चार्जशीट हो गया.
चार्जशीट हो गया, उस समय हमको याद है चार्जशीट नहीं हुआ था इसीलिए नहीं हुआ. कोई एंटीसीडेंट?
नहीं.
For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner has submitted that the bail application of the petitioner was rejected earlier on 18th of March 2026 in BA number 2170 of 2026, primarily on account of the reason that the investigation, that the matter was under investigation and charge sheet was not yet submitted. The bail was rejected at that stage. He has referred to paragraph 16 of the petition to submit that charge sheet has been submitted on 31/3/2026 and it has been committed to the Court of Sessions on 24/2026 and the next date for charge was on 23/4/2026. Charge हो गया? However, he submits on instruction that charge has not been framed so far. The learned counsel submits that after the rejection of bail order, a few co-accused persons have been also granted the privilege of anticipatory bail. The petitioner also does not have any criminal antecedent. The learned counsel for the state has opposed the prayer. With this, the counsel for the petitioner has submitted that the injury found is simple in nature and there are general and omnibus allegations against 300 to 400 villagers. After hearing the learned counsel for the parties and considering the fact that the charge sheet has already been submitted, the petitioner and the petitioner having no criminal antecedent, the petition is directed to be enlarged on appeal.
For admission item 4, CMP 281 of 2024 along with item 5.
There are two cases filed against the same restoration. In one case there is a वकालतनामा also. इसमें है? इसमें क्या है? इसमें भी वकालतनामा. ये किसका वकालतनामा? तो उसमें वकालतनामा है, तो जिसका वकालतनामा है उसी को रखेंगे ना फिर। अब क्लाइंट को आप पे ट्रस्ट नहीं रहा,
हम बात किए हैं तो बोले कि नहीं अभी
we will not permit this. When CMP has been filed with fresh वकालतनामा, we will not permit this. इससे क्या इससे क्या मतलब? आप ये कब किए हैं? 26 में। कहाँ है दूसरे वकील साहब? Where is he? देखिए CMP नंबर 299 of 2026 with CMP number 281 of 2024. The learned counsel for the petitioner in CMP number 281 of 2024 has submitted that the prayer for the petition was filed by him seeking restoration of WPS number 4494 of 2023 in the year 2024 itself, and for that, as per the practice and procedure of this court, no fresh wakalatnama is required. However, the petitioner has filed another CMP number CMP 299 of 2026 by filing a wakalatnama. He submits that the subsequent petition seeking restoration is not maintainable. Nobody is appearing on behalf of the petitioner in CMP number 299 of 2026. Accordingly, this petition is dismissed as not pressed. अब इसका बताइए।
ऑर्डर पर 15/3/24 को कोर्ट की ऑर्डर हुआ था।
Any private party? Any objection for restoration? There is a private respondent also. Notice नहीं। This petition has been filed for restoration of WPS number 4494 of 2023, which stood dismissed on 15/3/24 on account of non-removal of defects in terms of order dated 28/2/2024. The learned counsel for the petitioner submits that due to inadvertence, the defects could not be removed, and the counsel for the petitioner could not mark the list. The learned counsel for the respondents has no objection so far as the prayer for restoration is concerned. After hearing the learned counsel for the parties and being satisfied with the cause shown, the time granted for removal of defect in WPS number 4494 of 2023 by order dated 28/2/2024 is extended till 12th of June. 12th of June. If the defects in the repetition is removed within the extended time, the office is directed to place the repetition before appropriate bench as per roster. ऑर्डर फिर से प्रेम की है, दोबारा मत कर दीजिएगा डिफेक्ट।
Item 6, CRMP 1418 of 2026.
One of the children who are present there, one of the petition. So I stated a para number 4, madam. The bail petition, the petitioner was his friend, madam, who was left to Gujarat for work. And only come in October, madam. And one Mosaji of the petitioner is ready willing to become the creditor. Other condition, the other will be the close relative that will be.
ऐसे जो है ना एडहॉक आदमी को पैरवी कार्ड मत बनाएंगे, इसीलिए ऐसा ऑर्डर जो मिला उसको उठा के पैटिकार बना दिया, ऐसा नहीं होना चाहिए. CRFP number 1418 of 2026. This petition has been filed for modification of order dated 7/4/2026 passed in DA number 1147 of 2025. To the extent that one of the condition of the bail, inverted comma, Roman 1 of the bailers would be the present Padvikar of the petitioner, inverted comma close, be modified. The learned counsel for the petition submits that the Padvikar is the Padvikar of the petitioner in the bail petition was his friend who has now gone back to Gujarat to his work, and therefore he is not available. He has submitted that in his place, the Mausaji of the petitioner is ready to become his bailer, and therefore, and the other condition of the bail may remain the same, so both the bailers would be close relative of the petitioner. The learned counsel for the state has no serious objection so far as the prayer for modification is concerned. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, the order dated 7th April 2026 passed in BA number 1147 of 2025 is hereby modified, and paragraph number 5 within bracket Roman 1 is to be read as one of the bailers would be the Mausaji of the petitioner. वो अभी इसमें भी होंगे?
हाँ अभी है petitioner credit card वही है.
Who is the present Padvikar in the CNP? Office is directed to बाकी तो वही है. Whose name is Ramchandar Mehto, son of Prem Mehto, resident of Ram Kulbi, जो भी इसका affidavit का detail है. इस पर communicate.
Item 7, ABA 1847 of 2026.
The last order. 1640. It was directed to appear before the investigating officer. They have appeared. They have filed the counter at the they have admitted that they have appeared. But one paragraph of the counter was taken.
Which paragraph?
Paragraph. Paragraph 22 and also. The further stated that the petitioner pursuant order passed by this honorable court appeared before the IU on 22/4/2026. Again on 22/4/2026, I was directed to be appeared on 29. Paragraph 22. That stated petitioner pursuant to the order passed by this honorable court appeared before the IU on 22/4/2026
Yes, sir.
and on 29/4/2026. I was directed to appear on the next date also. Again I appeared and recorded his statement under section 180 of the BNS. The petitioner during his statement he detailed fact that one of the, after that the allegation has been alleged, but after that also one paragraph has been stated that during investigation it has been given paragraph 24 that Vinay Kumar Singh illegally transacted several crores of rupees on behalf of Vinay Kumar Chowdhury and the petitioner being the accountant of one of the companies of Vinay Kumar Singh, Nexian Solution Technology Limited could have vital information regarding transaction of money well, but during his statement he had pleaded complete ignorance regarding the same. For that they are saying that we did not cooperate with the investigation as they want our custodial information. That is on the admittedly we have joined the investigation. Your Worship, can you see 2-3 judgment on the same point? One, the judgment of Vijayendra. Your Worship, exactly on the same point, by the order of the court, investigation has been joined by the accused. Exactly on the same line, Your Worship, I am reading. The appellant is a junior engineer attached to the Municipal Corporation Sonipur. His plea for anticipatory bail has been rejected by the High Court, and the appellant is before us assailing that order that the allegation against the appellant primarily relates to taking a bribe to sign the proposal to enhance the cost estimated operating such as. After that, Your Worship, the Land Council for the state opposed his plea for pre-arrest bail by finding a counter. In our order, passed on successor giving the appellant interim protection, it was directed that the same protection was subject to the appellant's cooperation with the investigating agency. It is not in dispute that the appellant has joined the investigation, but the main reason for opposing the prayer for bail, the appellant for pre-arrest bail has been disclosed in paragraph 13 of the counter affidavit, which we quoted below. That the petitioner accused had though joined the investigation on dated such and such, as per the order passed by the Honorable Court, but the petitioner did not cooperate with the police, nor got recovered the amount of the bribe received by him, nor does disclose the other facts of this case properly. Therefore, the custodial interrogation of the petitioner accused is required in the present case for thorough investigation. We cannot read the behavior attributed to the appellant to be instance of non-cooperation, justifying dismissal of his appeal for pre-arrest bail, and accused by joining the investigation as a condition for remaining in large on bail is not expected to make self-incriminating statements under the threat that the state shall seek withdrawal of such interim protection. After that, the bail was confirmed. Similarly, what we can see on another case, that is also the paragraph 3. This order of 2026. Appellant has been arraigned as an accused offence number such and such, under section such and such, alleging that he had, along with other two accused, trespassed into the house of the complainant and committed theft of article lying in the house. The house is said to be in possession of the complainant on the basis of an agreement to sale, dated such and such. The appellant has been unsuccessful to the trial court and the high court. In other words, prayer for bail has been rejected. These court, while issuing notice on such and such, granted an interim protection, namely from any coercive steps being taken against the appellant, subject to the appellant cooperating with the investigation. The London Council appearing for the state could fairly submit that the appellant has appeared before the investigating agency, though not fully cooperating with the investigation, not answering the question of the IO, I'm reading paragraph 5 and 6. Not questioning the not answering the question of the IO would not ipso facto mean there is non-cooperation. Hence, we do not propose to go into the aspect, and it would suffice to note that the appellant has appeared before the IO pursuant to the interim protection granted and there being a civil dispute between the parties with regard to legal property. And on the same point, once we join the investigation, then we need the can't.
So I just want to know from you that in a case, in a standalone case, right, different from this. If the investigating officer is of the view that he is not cooperating, what remedy does he have?
He is not cooperating with the accused is not cooperating.
Accused is not cooperating.
But he appeared before the authority.
He appeared before the authority, but he did not cooperate.
But his statement has been recorded.
No, that's right. His statement might have been recorded. Yes. Whatever questions was put, it will reveal from the questions itself and question and answer whether he is cooperating or not cooperating. We are not here to judge whether you are cooperating or not cooperating.
Exactly.
But if the IO feels that you are not cooperating, what remedy does he have? What does he do? Practically, what will he do?
He will record the grounds of arrest.
He will record the ground of arrest. You see, so far as anticipatory bail is concerned, there is enough material against you. We just thought that you should get some protection. Let us just find it out.
Yes.
Then case of anticipatory bail is not made out.
Yes, that is my What is my allegation against you?
Yes, I have seen there is an allegation of destruction of evidence.
Yes, destruction of evidence, that has been discussed before the court below also. Your Worship, I can see the main accused, the witness saying.
You see, I know, main accused, everybody is there. You are the accountant, right?
Your Worship, I can consider.
You see, after all, it is just an interim protection and opportunity given to you.
In this case,
But I will decide the anticipatory bail on merits today.
Yes,
So I will decide it irrespective of your appearance or non-appearance.
Yes, Your Worship, I can consider this
Yes.
aspect also. Your Worship, this case was lodged in the year 2024.
No. You argue the case on
Yes,
merits.
yes.
2024.
2025. Occurrence is of 2023. Occurrence is of 2023.
Give me the dates, please.
Yes. The dates is only the occurrence of 2023.
Okay, let us just note it down.
Yes.
Incident is of 2000. Incident.
This is one more choice.
When was the PE initiated?
27/9/2024. 27/9/2024.
27/9/2024 PE.
PE.
Right? Yes.
Yes, I was not named in the PE. After 7 months or 8 months of the PE, on 25/2025, 20/5/2025, affair was lost against 30 named accused persons. 1-3. I was not. Neither my employer, the Vinasing was there. If the affair was lost against the employee of the JSBCL or the contractor who participated in the tender, neither the petitioner nor his company, nor the employer company participated in the tender. They having no concern with the JSBCL, they having no concern with the tender. All of a sudden on 3/6/2025, notice was issued to him under section 35(3).
What is the date? 3/6.
3/6/2025. Within 15 days of the FIR. On that day, admittedly, there was no material accused. The article has been seized also in the present case. That is from the showroom. The article has not been seized from the JSBC. These articles, these 33 computers, more than 150 documents have been seized from the different showroom of the employer in that month. In the month
Your employer.
My employer, I was one of the employees. He has been more than 100 employees. I was one of the employees. I was posted at Manchi. 33 computers have been seized, not from my position, from the position of the different person. Serially, they have been.
Person means it has been seized from the workplace.
From the workplace of the different, from the position of the different person. They are the same person. They have prepared the seizure list. They have seized the article, they have seized the CPU either from the Ranchi, Gumla, Dhanbad, Hazaribagh. I am residing at Ranchi. And they have seized from the different person 33 computers. It cannot be alleged against me that I was working in 33 computers simultaneously. Date on 3/6/2005, notice was issued to me under section 35(3). By that day, there was no material as against me. You can see the provision of 35(3).
Just a moment, that story is now over. 35(3), your appearance, your compliance,
Right.
because you only invited that order that you are ready to cooperate. So that's right. Therefore, I will not decide whether you are cooperating or not cooperating. I will decide the case on merits.
Yes, that's so that I am submitting a merit only.
Yes.
I am submitting a merit only that on 3/6/2005, the notice was issued. At that day, there was no material as against me. Only Bureaucracy Mechanism is their counter evidence. They have stated that only they came to know and they have some suspicion that something has been deleted from the computer. As such, they having suspicion that that matter relates with the present case. And this, admittedly, this is not the computer of the JSBC. As per my knowledge, the article which has been seized from the office of the JSBC, that has not been sent for the FSL. On 3/6/2025 I appear. On 6/6/2025 I appear. Again, notice was issued to me on 21/6/2025. 35(3). I appear on 23/6/2025. पूरा लिस्ट दिए हुए तब तो हम again. Even they called me on phone. That is on 15/8/2025. Who appeared on the same day. I appeared on the same day on their phone call on 15/8/2025. 9/10/2025 they issued a notice to me. I submitted an application that I was not available on that day, rather I will be available on or after 29/10/2025 because I was out of time. Now, again, the Lordship by the Lordship order, we appeared on 22/4 and 29/4. Now, let me tell you the seizure. In this case, my employer or the company director was arrested in one case of Lordship related with Hazaribagh. Because prior to that, on 7/7/2025, Vinasing has been released on anticipatory by the London court. Since there was no material as against him, he was released on anticipatory by the court.
Where is that order?
Yes, we have a record.
Your employer was released.
Yes, he was released.
Where is that order?
Annexure 2. Annexure 2 of the bill. Page 120.
120.
7.
He was released on 7/7/25.
Yes. 7/7/25.
Yes. And Caesar is on 28/9/25.
Yes, after that they have filed a bail cancellation also.
Must have, because they have now got the
Yes.
documents.
And that was dismissed by the court
That's true.
with a recent order. 7/7/2025 university, this bail was granted.
Okay.
Now you are saying when I was arrested, my employer was arrested on 29/2025, 25/9/2025. That is related with the Hazaribagh case. When I was appearing, I was called, even after bail, I was called. Vinay Singh was called before the ACB. He appeared. The same day, one another affair was instituted and he was arrested. After arrest, an application was filed by the ACB at Hazaribagh to make a search and seizure of the entire premises of the Vinay Singh. And it was submitted before the court that the evidence of that case is lying in these showrooms of the petitioner. Showroom of the employer of the petitioner. In this case, the showroom has been seized. Because showroom has been seized, showroom has been searched, and the entire CPU of the showroom has been seized. Showrooms, not at all concerned and connected with the JSBC. Seizure has been made eversive on 28/9/2025. And after that, it has been alleged that some of the CPU, more than 33 CPU have been seized. Because those related with the sale and purchase of the car. Because the employer of the petitioner is running a showroom of Tata Motors as well as Mahindra. He has been more than 4-5 showrooms. And all the showrooms have been searched, seized, and entire CPU have been seized, showroom have been sealed. And after seizure of the 33 CPU, not mechanically they speak the counter affidavit, they have annexed the seizure. They have annexed the seizure. From whom it was seized? Whether I was present at that time at the showroom? Annexure 8, page 11 of the counter. Page 11 of the counter. Annexure 8.
Yes.
SS Motorjet Private Limited, Tata Motors Showroom, Degree Ranchi, column 5. गवाहों का नाम पता जिनके समय तलाशी ली गई रंजीत कुमार, राजेश कुमार. And they have seized the articles. Page 12 पे also we can see the CPU, Dell CPU. They are more than 9 in number. That is in one seizure. And more than 150 other documents. Annexure to page 21. Annexure to page 21, that's another seizure of different showroom. Vijayant Anand. From page 21, it has been seized from the position of Vijayant Anand.
Not from you.
Not from him.
Very.
Not from him.
Got it.
And after that, it has been sent. Some of the CPU have been sent for the 3, not all. 3 have been sent for the FSL. Now, let's see, we can see the report of that. That is also with the counter evidence.
Yes. Yes.
Page 28.
Page 38.
Page 28 of the counter. Page 28 and 29.
Yes.
One CPU, memory observation based upon such and such. Page 30 also we can see. Based on preliminary examination of the storage media present, successor shows large number of deleted artifacts from unlocated clusters and large number of carved artifacts such as images and documents in the last 2 months. This indicates a deletion which is possible sign of temporary destruction of the digital evidence. Also, I am not coming whether it is evidence or not, because evidence, only the word of evidence will come when it will be produced before the court. It has not been produced before the court. It is the duty of the state to produce whether it is the evidence or not. It is the document so far. They can't say about it that is the evidence related with the present case. And 8 months have lapsed after this. Nobody it has come till today that whether any, because that can be distracted, that can be retried. But nobody it has come that what document has been, because those are the photographs of as per my.
Deleted documents से कैसे ही पता चलेगा
वो
कौन सा document?
retried किया जा सकता है. Those are the, it was argued also before the apex court. But the matter was same because of one of the employer of this.
देखिए एंटिसिपेटेड बिल का आपका केस नहीं
हाँ हम तो बहस कर दे रहे हैं, बट हम बता दे रहे हैं कि व्हाट इज माय
ये
रोल.
हम सुन रहे हैं
हम what क्या क्रिमिनलिटी मेरा है, तो मेरे अगेंस्ट बेसिक केस है कि हम कुछ एविडेंस को डिलीट किया. दैट इज द एलिगेशन. एट बेस्ट इट इज नॉट ए केस दैट आई एम द पर्सन जो जेएसपीसी में जाकर कोई घपला किया. एलिगेशन अगेंस्ट मी दैट माय एम्प्लॉयर हैज डिड समथिंग रॉन्ग, आई सपोर्टेड हिम. हम पे कौन सा केस बनेगा? एक्सेप्ट 238 कौन सा केस बनता है? 238 ऑफ द सेम यूनिवर्सिटी में कैसे द बीएमएस 238 पे अगर हम कोई एविडेंस को डिस्ट्रॉय करते हैं, अगर हम करते हैं, मान भी लेते हैं कि हम करते हैं, तो हम 238 के अलावा कौन सा सेक्शन है? यूनिवर्सिटी में क्या रीडिंग है 238. Whoever knowing or having reason to believe that an offence has been committed. Only because I am the accountant, or actually does not mean that every security is within my control.
certainly
And whoever knowing or having reason to believe that an offence has been committed causes any evidence of the commission of that offence to disappear with the intention of screening the offender from legal punishment or with the intention of any information respecting the offence. That is the available section. If the offence is punishable, if offence is punishable with imprisonment for life, or with even if the offence is punishable with death, and the one person having the knowledge that some offence has been committed and deleted the evidence, then that's available section. And in these cases, they have filed a counter evidence. But nowhere it has been stated that I have any concern with the business of the JSPC. If admittedly my employer, only suspicion has been raised that one Vinay Chaudhary, through one Vinay Singh, my employer, कहीं पे कुछ पैसा कहीं छुपाए होंगे. That was the main case. Whether the even it has been decided by the Honorable Apex Court that the case of money laundering cannot be investigated by the SCB or by the CBI. That can be done only by the enforcement director. Now let's say can you see the order, few order passed by this court, few order passed by the Honorable Apex Court as well as by the High Court Supreme Court related with this case. Let's say can you see, and I said to case supplementary. Yes, 22. One lead application was filed by the Vinay Kumar Singh, employer of the petitioner. He has filed a lead application before the Apex Court that even after the order granting bail by the Apex Court, he was not released, rather he was remanded in one or another cases thereafter. Then the court has observed in page 22.
you are not arguing the case of Vinay Kumar
No, I am saying that this very fact has been discussed and argued that the Vinay Kumar Singh is not cooperating. Then what was the answer of the court university that I am trying to demonstrate? What is the meaning of cooperation before the police? And this very case also, this very fact has been discussed. And this was also the issue. Page 23 also.
that was he was in custody at that point of time, or
He was in custody. He was
so
in
there is a
custody.
difference between the two when a person is in custody and when a person has been granted or his bail, regular bail is
Whether he
there.
will go for the whether the custodial deprivation is required or not, that he also has to be seen. What offence he has committed? Only being an accountant and having knowledge something about his employer, whether that will complete, that is sufficient to send him behind the bar. Only because he is the accountant, he is having some knowledge about his employer. There is no allegation that he is having any knowledge, giving any correction, because they have recorded the statement of the witnesses. None of the witnesses have stated to us they are known to the this petitioner. None of the witnesses have stated that they have any contact with this petitioner. Only they have stated that they have some contact with the witness, not with this petitioner. This petitioner is only one of them. They are not implicating this petitioner only. Rather, they are implicating chartered accountant of this Vinay Kumar Singh, one other employee of the Vinay Kumar Singh. And till today, also, they have filed the counter affidavit. They have not stated a single word that they have stated that crores of rupees. Because what I heard in this case, also, that there was no transaction at all. And only once the employee having the knowledge, my clerk having some knowledge about me, or that I did something wrong, he can be implicated. I don't think so that he can be put behind the bar. He can be implicated. He can be questioned by the police, but he cannot be put behind the bar. Page 23, your worship mechanism. Page 23. Issue an appropriate order on the direction destiny, because when the bail cancellation was filed related to the project case, that was also argued before the office. In this case, anticipative bail was granted to the Vinay Kumar Singh. It was also argued before the office. Issue an appropriate order or direction restraining the respondent from misusing the process of criminal law by seeking cancellation of the petition of one anticipative bail on grounds extraneous, irrelevant, or unconnected. That was the argument, page column 3. Now, let's see the non-cooperation. That was also discussed. Page 29. Page 29, let's see that was the argument of the senior counsel before the apex court about the role of the petitioner's employee in this case. Page 29. Page 29. There has been large-scale irregularities. I am reading from middle year. There has been large-scale irregularities under the Jharkhand excise policy also. And though in the initial FIR, mentioned as a friend of such and such, no role had been attributed to the petitioner number 1. That is the projected, that was the petitioner, the petitioner's employer. Page 33, your worship. Page 33. Even otherwise, the alleged non-cooperation of the petitioners with the investigation is to be considered with a pinch of salt. He says so far the simple reason that cooperation of the accused in the investigation does not necessarily mean and include that the accused would be rendering the confession to suit on the convenience of the prosecution. These many cases, this was argued before the court. And after considering all these, all 3-4 cases, he had been released on bail, that is to Article 30, considering the conduct of the state. And his wife was granted protection by the offense. Now, let's see page 14. This is the bail cancellation order. Bail cancellation application they have made. Page 57. Bail cancellation application was dismissed.
Yes, it was dismissed and ultimately bail was granted.
Bail was granted prior to that. After they have filed cancellation, on the ground that something has been deleted, then the court, answer of the court electoral mechanism. Even the 3 DFSR report, dated, that is the DFSR report, even the 3 DFSR report dated 12/10/2025 does not state anything specific regarding the deleted data to suggest that they were evidence of this case. The report only states about the possibility of tempering of destruction of the digital evidence, and on the basis of these 3 reports, ACB is seeking cancellation of bail of the OP accused Vinay Kumar Singh. Those are the same documents. The 3 preliminary report of diffusion action wherein there is no mention of the specific deleted data might be considered for diffusion of the anticipatory bail. But it cannot be considered for cancellation of the anticipatory bail already granted.
You are reading page number?
I am reading page number 57.
57.
The 3 preliminary report DFSR action wherein there is no mention of a specific deleted data might be considered for diffusion of the anticipatory bail, but it cannot be considered for cancellation of the anticipatory bail granted.
वही तो बोल रहे हैं आपका एंटिसिपेटरी बेल का कैंसिलेशन का बात नहीं है ना इसमें, जो ग्रांट ऑफ एंटिसिपेटरी
वही बता रहे कि ये मेरे एम्प्लॉयर के बारे में, मेरे एम्प्लॉयर के बारे में, उनके बारे में बोला सकता है कि उनका सामान है किसी के कस्टडी में है. आई एम नॉट द ऑनर ऑफ द सीपीयू. आई एम नॉट द ऑनर ऑफ द सीपीयू. एडमिटली इट वाज नॉट सीज्ड फ्रॉम माय पोजीशन. It has been seized from the position of the others only because आपको एक designation मिल गया accountant. That is in a private service. And though as per my information also we left the service now. Okay, the accountant का मिल गया है उसको, and only because his employer had did something wrong. For that they are appointing the bill. Though we have joined the investigation time and again and appeared before the authority.
Heard the learned counsel appearing on behalf of the petitioner.
Maybe.
आपको जब बहस करने का हिम्मत है ना तो ऑर्डर भी सुनने का हिम्मत है.
तो तो बता ही दिया ऑर्डर क्या करना है. पानी हमको तो
पानी दीजिए. पानी.
बहस तो बोली थी कि क्या करेंगे, तो सुनने का हिम्मत का बात है.
ये जो बात है ना, इस तरह से बहस करके बाहर चले जाना. आपका बहुत तरह का सबमिशन हम लिखाते हैं और उसके बाद क्या होता है कि कोई सबमिशन एरर हो जाए तो गलत हो जाएगा ना. आपने 15-20 मिनट बहस किया, हो सकता है कोई सबमिशन गलत हो जाए, रिकॉर्डिंग में गलत हो जाए, तो उसको कौन रेक्टिफाई करेगा.
तो हम लोग rectify करेंगे।
कौन रेक्टिफाई करेगा? अगर हम
हम
गलत कुछ
find out
दिखा रहे हैं
करेंगे।
आपके सबमिशन को तो आप रेक्टिफाई करेंगे ना कि हम
मुझे
ऐसा
लगता है कि ये
नहीं।
तो गलती हो सकता है।
जाइए, आपको जहाँ जाना है। मिस्टर गरोदिया को सुनेंगे हम आपका सबमिशन रिकॉर्ड करने के बाद। Heard the learned counsel appearing on behalf of the petitioner. The learned counsel for the petitioner submits that by virtue of order dated 16/4/2026, the petitioner was granted interim protection with the direction that the petitioner would physically appear before the ACB Ranchi on 22nd of April 2026 at 11 a.m. as the petitioner had submitted that he was fully ready to cooperate with the investigation if any interim protection is granted. The said protection was granted in view of the fact that the details of the notices issued under section 35 within bracket 3 of BLSS and the response of the petitioner were not placed on record. No, ये last sentence में. The learned counsel submits that the petitioner thereafter duly appeared on 22/4/2026 and 29/4/2026 in terms of the court's order, and his statements have been recorded. He submits that he has referred to the counter affidavit filed, supplementary counter affidavit filed by the ACB, and has referred to paragraph 22, uh, 22, 23 and 24 of the said affidavit to submit that the opposite party has taken a stand that the petitioner during his statement has pleaded complete ignorance regarding vital information of money trail, although the petitioner was accountant of one of the companies of the co-accused, Vinay Kumar Singh, that is Next-Gen Solution Technology Private Limited, Ranchi. He then referred to the judgments of the Honorable Supreme Court reported in SLP criminal number 20 of 2026, and has submitted that it has been held by the Honorable Supreme Court that not answering to question of the IO would not ipso facto mean that there is non-cooperation. He has then referred to the order passed in SLP criminal number 1079 of 2024 and has submitted that in the said case, interim protection was granted by the Honorable Supreme Court for the purposes of recording of statement, and the opposite party subsequently raised a plea that the appellant of the said case was not cooperating. However, the Honorable Supreme Court held that an accused, while joining investigation as a condition for remaining enlarged on bail, is not expected to make self-incriminating statement under threat that the state will seek withdrawal of such interim protection. The learned counsel submits that whatever answers could be given by the petitioner has been given during his interrogation, and the allegation made by ACB that there was non-cooperation from the side of the petitioner is completely misplaced. They cannot force the petitioner to make self-incriminating statements. The learned counsel then submitted that, so far as the merits of the case is concerned, he has submitted that the preliminary inquiry was initiated as that as on 27/9/2024, and neither the petitioner nor his employer was named named in the preliminary inquiry. Ultimately, the FIR was lodged on 25/2025 against 13 named accused. Amongst them also, neither the petitioner nor his employer Vinay Kumar Singh were named. He has submitted that the company of the employer of the petitioner, namely NextGen Solution Technology Private Limited, has got no concern whatsoever with the alleged offence. Rather, the present case arises out of scam relating to liquor policy of the state of Jharkhand, and the said company is nowhere related to JSPCL. The learned counsel then submitted that the computers were seized from the showroom of NextGen Solutions Technology Private Limited and not from the possession of the petitioner, and the petitioner was a mere accountant working in the said company. The learned counsel has submitted that Vinay Kumar Singh was granted anticipatory bail by the learned trial court as back as on 7/7/2025, and upon subsequent investigation/seizure, a petition was also filed for cancellation of his bail, cancellation of anticipatory bail granted to him, but ultimately the Honorable Supreme Court
No, district.
uh,
Bail cancellation district.
refused
District court may grant.
the sorry,
Bail was also granted by the special judge. We had filed there only the cancellation.
cancellation was allowed or
No,
rejected? The cancellation of the bail application was ultimately rejected
by the district.
by the district court itself. He submits that the petitioner, being an employer in the company of Vinay Kumar Singh, namely NextGen Solutions Technology Private Limited, and has got no complicity with the alleged offence, is entitled for anticipatory bail. और कुछ बोलना?
Even the allegation in the counter affidavit, there is no allegation with respect to any complicity with the occurrence.
The
Only
learned counsel
allegation
submits that even in the counter affidavit, no material has been placed on record by the ACB to connect the petitioner with the alleged offence.
Occurrence.
And
Only allegation
therefore,
with respect to tampering of the evidence.
He has submitted that the only allegation against the petitioner is with regard to tempering of evidence, in as much as certain digital records were found deleted in the computers seized from the office of NextGen Solutions Private Limited.
Which is bailable. That allegation.
He submits that even if this allegation is taken into consideration as correct, then also it is a bailable offence. That's all? Yes, state.
But if you see the sequence itself, we had stated that we had initially issued him notice on 3rd of June 2025. He had admittedly appeared and we had examined him up to 9th of June 2025. We had asked for some documents, he had given some documents, and at that relevant point of time, we had not arrested him under section 35(3). Thereafter, there is a crucial date, that is on 20. We received some confidential information that Vinay Singh, after being released on bail, was indulging in mass deletion and tampering and destruction of evidence, for which we conducted search and seizure operation under section 106 BNSS on 28 September 2025. And after the search and seizure, which continued on 28 September, 29 September, 3 days it went on. And immediately after, we had also seen digital devices as well as various books of accounts and other documents.
and since the petitioner was admittedly the accountant of NextGen Solution, in order to confront him with respect to those books of accounts and other relevant documents, so that we can further ascertain the facts about deletion or concealment of material facts, we had issued him again notice on 9th October 2025 under section 35(3) itself, asking him to appear. So that is a gap of around 4 months. We had again issued him a notice. Admittedly, my lord, he did not appear pursuant to the said notice, and my lord, had come before the trial court, and then her ladyship had granted protection and asked him to appear before us. He appeared before us on 22nd April and 29th April. And her ladyship, we have given her his statement why we are saying non-cooperation completely. There are two facts which I just want to bring to her ladyship notice. It's an 22nd April statement, if the ladyship may see first statement.
Yes.
Just para 2 and answer of para 2. क्या आप नेक्स्टजेन सोल्यूशन प्राइवेट लिमिटेड रांची में कब से कार्यरत थे एवं किस पद पर थे? मैं नेक्स्टजेन सोल्यूशन रांची में अकाउंटेंट के रूप से 2004 से कार्यरत था. तो he is working for last 21 years and more. Then kindly see one more thing which is very important, question number 9 and 10. Next page. नेक्स्टजेन सोल्यूशन प्राइवेट लिमिटेड में अकाउंटेंट के रूप में कार्यरत थे. आप फाइनेंशियल ट्रांजैक्शन डिजिटल डिवाइस के माध्यम से करते थे, तो डिजिटल डिवाइस का एक्सेस आपके पास निश्चित रूप से होगा.
9 and 10 of the next date.
No, of the same date, 22nd April.
अच्छा हाँ 22nd. ठीक.
9 and 10.
Yes, yes.
नेक्स्टजेन सोल्यूशन प्राइवेट लिमिटेड में अकाउंटेंट के रूप में कार्यरत थे. आप फाइनेंशियल ट्रांजैक्शन डिजिटल डिवाइस के माध्यम से करते थे, तो डिजिटल डिवाइस का एक्सेस आपके पास निश्चित रूप से होगा. मेरे पास डिजिटल डिवाइस का एक्सेस नहीं था. तो मतलब somebody who is working from 2004 as an accountant saying, and then क्वेश्चन नंबर 10, आपके पास डिजिटल डिवाइस का एक्सेस नहीं था, तो आप किस तरीके से नेक्स्टजेन सोल्यूशन प्राइवेट लिमिटेड रांची में अकाउंट मैनेज करते थे? क्या ऐसा माना जाए कि आप हमारे प्रश्नों का उत्तर सही तरीके से नहीं दे रहे हैं? नेक्स्टजेन सोल्यूशन रांची के डायरेक्टर के आदेश में मैं सभी कार्य करता था. मैं आपके प्रश्नों का उत्तर सही तरीके से दे रहा हूं. तो मतलब दिस इटसेल्फ शोज हिज कंप्लीट नॉन कोऑपरेशन, बिकॉज़ वी वर asking him with respect to the documents, more particularly the digital devices, where prima facie it has come that in FSL there is a mass destruction of data, and he denies, saying that I have no access and working as an accountant for last 2004. Now kindly see the next date, because we put him another question, 29th April, question number 3.
आपके दोनों 20-5 का ही हमको दे दिया है.
29 के दिन.
हाँ 29. ठीक है 29 April.
एक 22/4 का है, एक 29/4
हाँ
का.
ठीक. हाँ, इसमें कौन सा क्वेश्चन?
क्वेश्चन नंबर 3. जस्ट टू शो कि ही वाज नॉट ओनली द अकाउंटेंट, इसके अंदर में 10-12 लोग काम करते हैं. आप नेक्स्टजेन सोल्यूशन प्राइवेट लिमिटेड में कौन सा कार्य किया जा रहा था? मैं इस कंपनी में अकाउंटेंट से संबंधित कार्य देखता था. मेरे सहित अकाउंट विभाग में अन्य 10-12 आदमी कार्यरत थे, जिसका मॉनिटरिंग मेरे द्वारा किया जाता था. मेरे द्वारा गाड़ी का बिक्री हिसाब करो. So what we had specifically even asked him about the कि आप he was one of those.
जिसको एक्सेस नहीं होगा डिजिटल का, वो ये सब काम करेगा कैसे?
भाई हम कह रहे हैं कि अकाउंटेंट अगर है और 2004 से अकाउंटेंट है, उनके अंदर में 10-12 एम्प्लॉय काम कर रहे हैं, तो ही इज द पर्सन हु हैज SAP डॉक्यूमेंट्स आजकल रहता है सारा चीज है. एंड अनदर थिंग हर लीडरशिप में सी, ही सेड दैट ही हाँ, ये अब बोलते हैं कि हम 2005 से एक बार काइंडली उत्तर नंबर 5 क्वेश्चन प्रश्न 5, वर्तमान में आपको कंपनी में कितना वेतन मिल रहा है? मैं अक्टूबर 2005 से उस कंपनी का हिस्सा नहीं हूँ. उस कंपनी में सितंबर 2025 तक कार्यरत रहा, जिसके लिए मुझे सैलरी और इंसेंटिव. All these are,
You see whether he is cooperating, not cooperating, we are not here to judge that.
yes,
That is your prerogative.
correct.
But the point is, that whether he should be enlarged on anticipatory bail.
So-
If you issue him fresh notice, if he comes, what do you think about him? We are not bothered about him. You have your own remedy if he is not cooperating. If you think that he is not cooperating, you have your own remedy. We are not going to pronounce on his cooperation or non-cooperation. As on date, if you issue him notice, if he comes, it's okay. If he doesn't come, then also it's okay.
Yes, that is very
Now you just tell us pinpointedly from the records as to what specific allegation has been made against him in order to substantiate your case that he is not entitled to anticipate.
Yes, my specific allegation is that he being the accountant of the company and dealing with the transactions of Binay Kumar Singh for a very long period was knowing about the transactions pertaining to Binay Kumar Singh, including the transactions with respect to deletion of data and tampering of evidences, which he has not been, which we need to confront him with the other accused persons as well, and this is the specific allegation against him.
The learned counsel for the opposite party has submitted that prior to filing of the anticipatory bail application, notice was issued to the petitioner on under section 35(3) of BNSS on repeated occasion. The first one on pursuant to which he appeared was on 3/6/2025, and subsequently on 9/6/2025 he was asked to submit certain documents, which he duly did, and therefore there was no occasion for the ACB to arrest the petitioner. He submits that once Binay Kumar Singh, his employer, was released from jail, he was granted anticipatory bail.
And he was granted anticipatory bail.
He was granted anticipatory bail. There was the ACB came to know that he is involved in large-scale destruction of digital evidence.
Destruction of material evidences, including digital evidence.
Destruction of material evidence, including the digital evidence. He has submitted that pursuant thereto, raid was made in the company, in the showroom of NextGen Solutions Technology Limited, and
there were 5 companies, but we are concerned with NextGen Solution because he was working.
On during the period from 28/9/2025, and huge number of digital devices and documents were seized. And thereafter, when it was sent for FSL examination, it came to light that there was destruction of digital evidence from the digital devices. The learned counsel submits that the petitioner was the accountant working in the company for since 2004, and under him 12 to 13 people were also working, and he was the accountant in the company. And during his examination, he was confronted with many questions to which he gave evasive reply or refused to reply. The learned counsel submits that the ACB may issue fresh notice upon the petitioner, since as on date the warrant of arrest has not been issued against the petitioner, and otherwise also in case of non-cooperation, the opposite party has got the right to arrest the petitioner. But so far as anticipatory bail is concerned, he is not entitled to anticipatory bail in view of the materials which are being posed against him. He submits that for the purposes of collecting the material, the petitioner is required to be confronted with other co-accused persons, and on account of his evasive replies, custodial interrogation is necessary of the petitioner. That's it?
But as per the submission of my learned friend, only allegation against me that I have some knowledge and I am not cooperating with them. That is their case. There is no allegation against me that I have committed any offence. Only allegation that some person have committed the offence. I have the knowledge that who has committed the offence and I am not cooperating with the investigation. And I am not saying against them. That is their case. Whether for that any case is better than the for that only you are saying only for record evidences and to implicate someone whether one innocent person can be seen behind the bar. So that they can get something to implicate someone else. In this case, Lordship, we kindly see that the case has been issued in the month of May 2025. Till today, not a single charge sheet has been submitted. Even Vinay Chaubey has been released on bail, that is on default bail. Not a single charge sheet has been submitted, not a single accused Lordship against whom there was allegation and he has been charged. My case is that admittedly I have no concern with the entire offence. Only allegation against me as per him that I have some knowledge that someone has committed the offence and I am not cooperating, I am not disclosing against him. Whether that will constitute any offence against me. And you also may kindly see one judgment that only for the requirement of the document, anticipatory bail cannot be denied. If they want to know something from me, they can issue the notice. They can what they are saying that they want to put confrontation with the other persons. Other persons are on bail. They are calling in one another case. One Vidya Singh Lordship, they have called in another case, that in the case of DA, 14 times in 10 days. In 10 or 14 days, we have the list. For every day he was called. Even after the order passed by the apex court, he was called each and every day and he was present before the SCB. And even from the beginning, before they were actually, they can वो हमको बैठा सकते हैं and after that they can ask the question if they want to. Vinay Chaubey has been released on bail in these cases. Everyone on bail. And what is the allegation against me? Only because that I have some knowledge. First time also they are trying to send the person behind the bar only to get something from him as a witness. They can ask me as a witness. Instead of that, they have made me accused. एक जजमेंट है एक पैराग्राफ पढ़ना इसी पे डॉक्यूमेंट्स में है और उसका रिक्वायरमेंट नहीं था फॉर दैट एडमिसिबिलिटी बिल वाज अलाउड बाय द कोर्ट एक पैराग्राफ पे लिखना
डॉक्यूमेंट की तो बात ही नहीं है इसमें. The learned counsel for the petitioner in response has submitted that upon perusal of the entire counter affidavit, there is no reference of any material collected against the petitioner to connect him with the alleged offence, which is primarily against his employer and other co-accused. He has submitted that at best the petitioner could be a witness, but the petitioner is neither the beneficiary of the alleged offence nor has any role in the alleged offence. He has submitted that the role of that in such circumstances there is no need of any custodial interrogation. The learned counsel has further submitted that if the petitioner is to be confronted with other co-accused persons who are already on bail, then under such circumstances there can be no reason that the anticipatory bail be denied to the petitioner. He can still be confronted with other persons who may be called for further interrogation in the case.
He is ready to cooperate with him. Even on phone calls, he actually repeatedly appeared before him. And as my learned friend has said, he provided all the documents, whatever they asked.
After hearing the learned you have only filed one counter affidavit?
No, one.
After hearing the learned counsel for the parties and considering the allegation as indicated against the petitioner, it appears that the petitioner is sought to be made an accused being an employee of NextGen Solutions Technology Private Limited working as an accountant, in which Vinay Kumar Singh, the co-accused, is the director. It is further, as per the counter affidavit, it has been mentioned that due to non-cooperation of it has been alleged that in paragraph 13 that during the course of investigation, confidential information was received that suspected accused Vinay Kumar Singh was tampering with the material evidence in respect of pending investigation, including mass destruction of data resulting into tampering and destruction of digital evidence. Consequently, there was search and seizure with respect to the properties relating to Vinay Kumar Singh, and the various showrooms were also searched, including NextGen Solution Technologies Private Limited branch, and several incriminating documents including digital devices were found, and it was found necessary that the premises be sealed to prevent tampering of evidence. The digital devices were sent for forensic examination, and it was found that there has been mass deletion of data, which is a possible sign of tampering or destruction of digital evidence. And on the basis of aforesaid, it has been alleged that it would be evident that Vinay Kumar Singh, who is suspect accused on one hand, was not cooperating with the investigation, on the other hand, was indulging into destruction/tampering of evidence, due to which search and seizure operation was required to be carried out. Further, the role of the petitioner is mentioned in paragraph 20 of the counter affidavit, wherein it has been stated that the petitioner was working as an accountant of NextGen Solution Technology Private Limited and has direct access to the digital devices data and material, which as per the FSL report has been confirmed to be deleted recently, and therefore the role of the petitioner in deletion of such data is highly possible. And it has been alleged that during course of recording of his statement, the petitioner pleaded complete ignorance regarding deletion of any data from the digital device and has been giving evasive reply, and it has been asserted that hence custodial interrogation of the petitioner is required. This court finds that from the entire counter affidavit, no material has been mentioned connecting the petitioner directly or indirectly with the alleged offence. It is not the case of the respondents, opposite party, that petitioner is a beneficiary of the alleged offence in any manner, and they have specifically made a statement that the role of the petitioner in deletion of such data is highly possible. This court is also of the view that if the petitioner is required to be interrogated by confronting other co-accused persons, he can certainly be put across the co-accused persons who are already enjoying the privilege of bail. There can be no doubt that under any circumstances, the petitioner cannot be forced to make any incriminating statement against himself. Petitioner at best In view of the aforesaid facts and circumstances, this court is of the considered view that the petitioner is entitled for anticipatory bail, which is hereby allowed, subject to what conditions do you want?
Cooperation with the investigation hasn't been called, confrontation or
Cooperation with the investigation, securities, क्या चाहिए आपको?
security or 2 lakh.
2 lakh, 2 securities. Sorry,
ये अकाउंटेंट ऑलरेडी लॉट है तो
आपका विनय कुमार सिंह देंगे?
खरीद करना ही पड़ेगा।
कुछ मटेरियल ऐसा आया नहीं, इतना नेगेटिव मत सोचा, इतना कोर्ट से भाग जा रहे हैं। क्लाइंट लोग एंशियस होते हैं, वकील कहीं एंशियस होते हैं?
प्यास लग रहा था
हम लोग दोनों को लगा था कि रिजेक्ट हो रहा हम
नहीं, ये जो पॉसिबल देखे ना सेंटेंस,
हाँ वो तो है,
that is
वही
catching.
बोलेंगे। हाँ
बाकी सब में तो आप सबका स्टेटमेंट वगैरह लगाते हैं, कुछ हम तो 164 का स्टेटमेंट में भी हम एंटिसिपेटरी बेल रिजेक्ट कर दिए कि बेल ही शायद रिजेक्ट कर दिए किसी के
खिलाफ जो है वही
है। यू कैन नॉट कुक अप थिंग्स, नो, इट इज नॉट पॉसिबल। अभी तक आप पॉसिबिलिटी की बात कर रहे हैं, कोई इनके साथ कोई मनी ट्रेल, कोई बेनिफिशियरी, कुछ नहीं है। जाने दीजिए अकाउंटेंट को शांति से। ठीक है, 2 lakhs 2 securities एंड पासपोर्ट है, जमा करा दीजिएगा।
अगर होगा तो ये लिखवा दिया, अगर होगा तो जमा।
ठीक, आपको एक चीज बता दे रहे हैं, जितना देर हम आपसे सवाल पूछ रहे हैं उतना ही देर मेरा माइंड ओपन है। जब सवाल पूछना बंद कर दें तो समझ लीजिए माइंड मेकअप कर चुके हैं। दिस मच ऑफ रीडिंग यू शुड हैव ऑफ द कोर्ट।
आज ये भी फेल कर गए।
नहीं आप हम रेस्पोंडेंट से उर्दू जब बोलती है मैलॉर्ड कहती है कि इनका बेल रिजेक्ट होगा तो भी हम बहुत जोर से मतलब जिसमें करना है।
हाँ, जिसमें करना है कोई मटेरियल नहीं है इनके आगे, इसमें जबरदस्ती इनको जेल में नहीं डालना। ये लीजिए, नीलेश कुमार जी बहुत ज्यादा एग्रीव रहते हैं इसको। हाँ, क्या करिएगा, आपका केस ही सब ऐसा रहता है।
For hearing item 8, WPL 2071 of 2012.
Yes. Passover. Yes, who is for the respondent? उतना ही चाहिए आपका इंटरेस्ट वाला, इसके अलावा कुछ?
थोड़ा सा ये हो
Let him come. What do I do? He's not there. उनके absence में कैसे बहस? Tuesday. आपका मैटर्स किस दिन गया है?
वाला थे लेकिन हम ध्यान नहीं दे रहे।
मंडे को रखते हैं?
थोड़ा सा मंडे ट्यूसडे का खाली
आपका और केस रखा हुआ उसको हम एडजर्न नहीं करेंगे। आई विल नॉट एडजर्न, वो आप कर लेंगे।
ये माइकस सर का नाम लिखा गया है इसमें थोड़ा सा।
ठीक है, WPL number 2071 of 2012. At the request of the learned amicus, the counsel for the petitioner is present. However, at the request of learned amicus, the matter is adjourned by way of last indulgence and is directed to be posted on Wednesday. 215. First case. 215. दिक्कत है Wednesday.
11 तो हमको 13 तो दूसरे केस में कोई कंटेम्प्ट से
4 बजे लग जाते हैं। 4 o'clock.
From dailies for orders, item 1 contained civil 1340 of 2025.
This matter pursuant to the last order, that is 17/14/26, the state was directed to file a fresh show cause. ये तो पिछला शो कॉज ऐसा आ गया था कि ऑनरेबल कोर्ट के ऑर्डर को सेक्रेटरी साहब मॉडिफाई कर आपने कहा प्रमोशन देने के लिए सेक्रेटरी साहब बोलते हैं नहीं मिल सकता है
क्या
The leadership, the district establishment committee has conducted a meeting and they have sent this the meeting details to the director for the approval. So they need only 2 weeks time to file.
क्या किए मीटिंग में इनके फेवर में किए क्या अगेंस्ट
Your leadership, that is not known to us. They said that they will let us know because they have conducted the meeting on 4th. And they have sent
Content case civil number 1340 of 2025. The learned counsel for the opposite party submits that the required meeting has been conducted
on 4th of
on 4th of May of Departmental Promotion Committee of the district and the proceeding has been sent to the Director of Primary Education for required approval. She submits that the matter be posted after 2 weeks. Considering the submissions, the matter is directed to be posted on 12th of June 2026. The supplementary show cause annexing the final decision, annexing the report of Departmental Promotion Committee and also the final decision of the Director of Primary Education be placed, be filed latest by 9th of June.
For first filing item 2, BA 3863 of 2026.
क्या
जो कॉन्फ्यूज को जो लोग पंक्ति में उन लोग उनके पास आराम भी कभी वाला ध्यान ग्रांटेड हुए और ये विचार जैसा बोलते हैं अपनी हम 30 हम लगा के आर्गुमेंट लोग खत्म हो गया उसके एविडेंस ही समाप्त हो चुका है
आपका अर्लियर रिजेक्टेड है ना
हाँ अभी रिजेक्टेड है 10/3/26 को हुआ था
क्या करेंगे
इसके बाद एट दिस स्टेज और लास्ट में दिखाया
10/3/26 को रिजेक्ट हुआ था एट स्टेज मतलब
मेरा प्लीज अकॉर्डिंग टू एट दिस स्टेज नाउ 186 सबमिट नहीं हुआ था 85 में सबमिटेड and charge and also framed. So these are the studies in 9/1/26. Two co-accused who settled the informant, they have been granted reform whose proposition arms were recovered. It has been stated by the co-accused, I asked them to settle that person for a case of 2013. उस case में हम accused नहीं आ रहे, unless and exception can be received. I am not the accused in that case person. Case is 19 sold accused Jayan Tiwari. I am not the accused in that case also. You will know reason. And that is where उसमें evidence भी खत्म हो चुका है. मतलब कोई case ही नहीं खत्म.
आपका चार्ज फ्रेम कब हुआ
ये इंटरव्यू ऑर्डर में आया है. दस का इंटरव्यू ऑर्डर इस तरह से. और देखे भी हमें ये पेज 25 देखा जाए. 22/4/26 डेट फिक्स था. Today I am on the child education. Today I am
ऐसा इंफॉर्मेशन
child for 9 minutes. Now the case is pending for hearing on child. Next date is 22/4/26.
क्या करेंगे पॉजिटिव स्टेटमेंट होना चाहिए ऐसे आपका स्टेटमेंट
Not see on that date, between that date the child was not framed.
आपको रुकना चाहिए था ना चार्ज फ्रेम करने में
Now child is framed. Today I asked, I am informed that child is framed. And in the studies since 4 months also. दो महीने तुम से कोई भी नंबर डिपेंड नहीं है नेक्स्ट that page 20 में क्या लिखा है या फिर अपडेट
आपके ऊपर क्या एलिगेशन है एफआईआर में यू आर नेम्ड इन द एफआईआर
No, sir, it has been stated by the co-accused. The co-accused certain one person. You withdraw that case from 13 ka, otherwise they will give you a certain. They have used and certain that person. वो mobile that mobile one भगवान मंडल से लेकर आशीष मंडल has taken that mobile. From that mobile to आशीष मंडल settled the person. Chief Mandal told that I have asked him to threaten that person for the case of 2013.
How are you connected with the case of 2013?
I have stated I have no concern in that case, Lord. I am not accused. I have no concern, Lord. I understand you, Lord, and exception may be used. The sole accused is one Jayant Tiwari. My father is also not Jayant Tiwari, Lord. In that case, evidence is not Lord's argument करें. ऐसा कुछ नहीं है. I have stated in class, I have nothing to do with that case also.
आपसे रिकवरी भी है?
नहीं हमसे नहीं है. हमसे कोई रिकवरी नहीं है. आशीष मंडल से रिकवरी है. हमसे कोई रिकवरी नहीं है, कुछ नहीं. Only on the
क्या बोलना है? चार्ज फ्रेम हो गया? क्या बोलना है? कोई एंटीसीडेंट?
एंटीसीडेंट एक मारपीट का है जिसमें बेल पे एक एंटीसीडेंट.
कब का? आपका सबकी वजह से वर्बल चलता है. What is this? आपका किस केस में एंटीसीडेंट है भाई? किस तरह का केस में आपका एंटीसीडेंट है? आप सुपारी लेते हैं? तो फिर कैसे पता?
हम पूछे मारपीट का केस हो गया.
कहाँ से मारपीट?
हम डाल देते हैं उसको सप्लीमेंट्री फाइल कर देते हैं. कोई वैसा केस नहीं, इस तरह का कोई केस नहीं है. अब मेरा स्टेटमेंट को रिकॉर्ड कर लिया. ऐसा कोई स्टेटमेंट नहीं.
मैडम आपका स्टेटमेंट को रिकॉर्ड करके आपको डॉक्यूमेंट नहीं खड़ा करना है. ठीक है ना?
I specifically asked इसके बोले कैसे छोटा मोटा मार्केट का नहीं हम गए बता.
हम बोलिए क्या बोलना है? What do you want to say? कस्टडी में आप कब से?
9/26 4 months.
The learned counsel for the petitioner submits that the bail application of the petitioner was earlier rejected by this court in BA number 1330 of 2026 by the order dated 10/3/2026. At that stage, she submits that by that time the matter was under investigation and consequently the charge was not filed. She has submitted that now the charge has been filed. The learned counsel further submits that so far as the merit of the case is concerned, there is nothing against the petitioner to connect with the alleged offence. She has also submitted that there is an allegation regarding threatening of the informant in connection with a previous case pending since 2013. But the petitioner has no concern at all with the said case. The petitioner is in custody since
9/1/26.
9/1/2026. The learned counsel for the state has आपका आर्म्स एक्ट में भी तो आपके अगेंस्ट पे चार्ज फ्रेम हुआ.
कुछ नहीं हुआ.
रिकवरी नहीं है आपके पास आर्म्स से?
नहीं FIR में लिख लिया रिकवरी में से नहीं.
FIR में तो आपको तो सप्लीमेंट्री चार्जशीट में कुछ बनाना है.
मेरे एजेंट में कोई रिकवरी इसमें आया नहीं, रिकवरी किसके पास है? FIR नहीं है.
The Learned Counsel for the state, though has opposed the prayer, but does not dispute the aforesaid submissions made by the Learned Counsel for the petitioner. After hearing the Learned Counsel for the parties and considering the fact that charge has already been paid, the petitioner is directed to pay enlargement fees. Conviction एक लगाएगा, will not disturb the other witnesses of the case.
Permission item 3 contains civil 1002 of 2025.
What happened in this case?
Leadership order has not been complied with. On the last date, leadership
You have filed your affidavit.
Yes, leadership, I have filed a and on the last date,
Yes,
leadership.
how many persons have been, how many associations have been identified and recognized so far?
The affidavit of leadership is absolutely silent on the.
Leadership भी मैंने
Election.
submitted photos that is of page 19.
Yes, I am seeing that. Annexure B is what?
This is a recognition of services association under CCS.
No, we are not on that. You see, all the time you are extending the life of the association by saying that you are in the process of identification,
Verification, yes.
verification. So I want to know that for last couple of years, you are in the process of verification. How many verification have you done?
Just for a moment, there are 9 of my affidavit in this.
Yes.
There are ongoing 5 litigations, Pan India Mallet at Delhi High Court, then Karnataka High Court and Madras High Court. We have stated that Para 9 leadership will take. This is coming in way to complete the verification.
No.
So,
I want to know what have you done so far. I want to know this.
current status.
No, yes, you see, if there,
No, I got it, I
let
got
us
it, probably.
let us see it this way. FIR has been filed.
I
You
got
say
it.
it is under
I
investigation.
got it.
So I want to know how much have you
I got it.
investigated.
I got it. When we,
You see, what is happening is that they are under.
extension, no, they are not to,
No,
to any
please
predicament.
appreciate.
Right.
The life of the association was maybe 31st of December 2025, right? So I pass an order so that their discontinuation or the de-affiliation
Yes, yes.
will be only till 31st of December,
Yes.
right? Now what have you done? You are extending the period life of the association
Year to year basis. What is
on, you are from time to time, and consequently their de-recognition is also extending.
it? Two small submission. One point I got it because I was not there. Probably this communication gap would have been.
No, it's there, black and white में हम order करते थे तब हमारा आपको
नहीं
बोलते
हम
communication
हम
gap.
इस समझ पाए आज हम
आप थे नहीं ना, इसीलिए आप नहीं समझ पाए.
30 जून को मेरा एमपीए भी लगा हुआ है हमको एक इंटरफेस दीजिए बिफोर दैट वी विल कम विद दैट व्हाट इज द स्टार्टिंग योर लीडरशिप वांट्स दैट व्हाट इज द स्टेज ऑफ वेरिफिकेशन
Yes, how many? You see, you are saying
investigation what is the stage
you are saying that you are doing the verification
I
of
got it.
various associations. में 3 साल में कोई तो association का verification complete किया होंगे कि नहीं? How many associations have got a clean chip from you?
one indulgence I feel one indulgence.
Leadership, if I
Let me because this has to be answered. This cannot go because they cannot be presenting perfect feature indefinite.
तो क्या आपके litigant आए कुछ बोलना चाह रहे हैं? कुछ बोलना चाह रहे हैं आप?
बोलना चाहिए
आप किनकी तरफ से हैं?
ये
Your?
नहीं here's my office.
अच्छा, your officer. Ask him. कुछ हो भी रहा है कि बस ऐसी extension चल रहा है?
Leadership, if I may submit, the ground which they have taken is that the pendency of several writs at different high courts leadership. Leadership, Honorable Tamil Nadu High Court has already decided the matter in which they have acquiesced to the wisdom of leadership and they have clearly stipulated that once Honorable Jharkhand High Court has passed the order, I have the order with me, leadership. Tamil
चलिए
Nadu,
तमिलनाडु हम लोग का order
Tamil Nadu has clearly agreed with the order. Then leadership,
Vijaya Mishra is also quoted on and off. This is a grey area, though. My lord is taking
writ which is pending at Honorable Delhi High Court leadership, it is completely different. It pertains to the recognition of NFP leadership. NFP is an umbrella body. We had not challenged the recognition of NFP. Furthermore, leadership, the writ which is pending at Karnataka High Court is also completely different leadership. because they are pertaining to
ऐसा
only
नहीं
recognition
कहेंगे,
of the
आपके घर का
circle.
एसोसिएशन नहीं है. You see, huge rights and huge amount of otherwise which they are entitled through the association. This association is a bargaining body. आप इसको इस तरह से नहीं क्रश कर सकते. ये extend कर करके. What is this? आप किसी को आप एक बात बताइए, लाइफ सेंटेंस में आप किसी को लाइफ तक ही ना करेंगे, उसके बाद आप बोलिए नहीं लाइफ हम 200 साल एक्सटेंड करेंगे. ये भी बढ़
तो वेंटिलेटर पे रख दिया इसको.
This is not acceptable to us.
Keep one sentence. And one more update that was there, that is finally it is coming on 30th June, that has been faced with the division bench. But I am not onto that because there is no issue.
देखिए हमको मेरा ऑर्डर दिखाइए.
Issue this is Honorable Tamil Nadu High Court.
Your research will enlighten us also.
Para 23 में DC litigation. If I may place the same issue. Para 23 litigation. In the light of the detailed judgment of the Jharkhand High Court, where this very relief was sought for, I see no reason to hold otherwise. From a perusal of the records, it is clear that the parent body of the petitioner association has violated certain conditions which gives the respondents the right to invoke the provisions of this recognition. However, as observed by the High Court of Jharkhand, when recognition is valid for 5 years, de-recognition cannot be indefinite. And prior to that leadership from para 18 onwards, the judgment rendered by this honorable court has been discussed leadership. In para 21, the findings of your leadership has been quoted as well. The Honorable Tamil Nadu High Court has gone on to hold the same.
So, your officer will provide the details.
I will call the lawyer, just I will discuss and I will come with a positive note. Because now they have given me 4 weeks. My friend is saying that those are involving different issues. So I cannot then make a submission which apparently will appear to be misleading. So my submission would be that give me one indulgence.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the order passed by this court in the writ petition has been followed by Honorable Madras High Court in judgment dated 4/8/2025, and they have taken the same view. The learned counsel further submits that in the supplementary show cause filed by the opposite party, the reference to the various pending litigation has got no relation with the present one, which was involved in the connected writ petition. He has further submitted that the order passed by this court directing the opposite party to file a supplementary show cause by order dated 1st of May. Order dated 1st of May 2026 has not been complied in letter and spirit. He has submitted that in the supplementary show cause there is no development projected to show that the opposite party has been taking any step in the matter of recognition of the various unions. To this, the counsel for the opposite party seeks adjournment and has submitted that the case is finally coming up before the LPA court on 30th of June 2026. Post on 3rd of July.
Gratefully. Any charge
कर लीजिए अपना LPA.
Because that is very logical and very fundamental. Blacklisting cannot be indefinite. 5 years we have
वही
given timeline.
same principle I have applied.
Now I have got it.
De-recognition of an association can never be indefinite.
And also when it is prescribed for 5 years.
5 साल का लाइफ है उसका लाइफ बढ़ा दीजिए और उसका de-recognition भी बढ़ा
दीजिए. Deadly combination that de-recognition is also going and extension is going.
Our leadership, what they are doing even in March 2026, they have issued a letter circulating that de-recognition order again to all service leadership. I have annexed in my supplementary my reply as well.
My friend is today is to bulldoze me. Let me take it. Gratefully.
वो ब्लैकलिस्टिंग वाला ही प्रिंसिपल लगा है, वही प्रिंसिपल पर ही हम जज करेंगे.
And it's so clear. I had not gone through it.
supply.
Item 5 CMP 1185 of 2025.
Yes. What are you saying? क्या मॉडिफिकेशन चाहिए?
हमको देना है रेस्पोंडेंट नंबर 7 को 5,000 वो हमने जमा कर दिया लेकिन डिले
जमा हो गया? CAP number 1185 of 2025. The learned counsel for the petitioner submits that the direction to pay cost in terms of CAP number 993 of 2023 by the order dated 25/4/2025 as contained in paragraph 5 of the said order has been complied but belatedly. Counsel for the opposite party submits that his client has received rupees 5,000 as indicated in the said order. To this, the learned counsel for the petitioner submits that the deposit of cost, though belatedly, be accepted as compliance of the paragraph 5 of CMP number 993 of 2023. And time for payment of cost be accordingly extended. Considering the submissions, the order dated 25/4/25 passed in CMP number 993 of 2023 is hereby modified to the extent that the time for payment of cost is extended till today. The parties have jointly submitted that the cost has already been received by the opposite party. Therefore, the order stands fully complied. The writ petition is directed to be listed before appropriate bench as follows. WPC 499 of 2022. यही है ना? ठीक है? बाकी सब डिफेक्ट? अच्छा, अभी बाकी डिफेक्ट नहीं रिमूव किए हैं? The time for removal of defects granted by the order dated 25/4/25 in CMP number 933 of 2023 is further extended till 12th of June. If this order regarding removal of defect is complied, office is directed to place the writ petition before appropriate bench as per procedure.
Item 6 CMP 1198 of 2025.
Yes. Restoration. इसमें क्या restoration करेंगे? बताइए, there is nothing in the merit. चौकीदार का अपॉइंटमेंट चाहिए, हेरिडिटरी अपॉइंटमेंट. नहीं, आई एम नॉट इम्प्लाइड. आप हाँ क्या चीज? इस आप रेस्टोरेशन क्यों फाइल करते हैं? आप एडवाइस नहीं करते हैं? द लॉ इज सो क्लियर. तो फिर नहीं, I will not. You see, I will just record that so far as this aspect is concerned, it is not in dispute. Law is very clear. हो गया, hereditary right नहीं है चौकीदार अपॉइंटमेंट में. आप क्या बच्चा? तो फिर नहीं, इस ग्राउंड पे हम आपका रेस्टोर नहीं करेंगे. नहीं नहीं कुछ नहीं क्या होना है इसमें What is the ground? What is the which paragraph have you taken? कहाँ लिखे हैं? Ground बताइए आपका. What is your ground? पढ़िए. ये what is the ground for non-appearance of the council? कहाँ लिखे हैं? बहुत अच्छी बात. CMP number 1198 of 2025. For the learned council appearing on behalf of the petitioner. This petition has been filed for restoration of WPS number 5480 of 2018, which was dismissed for non-prosecution by the order dated 21/6/2022. The learned counsel for the petitioner submits that the petitioner came to know about the dismissal of the case much later, and thereafter the prayer for therefore the petition for restoration has been filed. During the course of hearing, the learned counsel for the petitioner does not dispute that the hereditary right, the so-called hereditary right of Chowkidar does not survive anymore. And the petition was primarily filed seeking hereditary right for appointment of Chowkidar. To this, the counsel for the petitioner submits that once the petition is restored, the case may be decided on merits. The learned counsel for the state has opposed a prayer for restoration. Oppose करने की support कर रहे हैं. And submits that there is no sufficient explanation for non-appearance of the counsel in the petition, and the petition for restoration has been filed by another counsel. After hearing the learned counsel for the parties, this court is not at all satisfied with the cause shown by the petitioner seeking restoration of the writ petition. Otherwise, also no useful purpose will be served by restoring the writ petition. Accordingly, the CMP is hereby dismissed. Just give us a minute. this one.
Item 7, CMP 1209 of 2025.
Yes, ma'am.
Notification of judgment in integrated 27/2025 passed in FA 76. Decree has been prepared without considering the interest and may refer to page 14 of the petition. That is order of the trust. There is the lands has been placed on FA 35 of 1994 and the FA was partly allowed. In that case also the interest part was not considered during preparation of decree and thereafter applicant has preferred modification CMP 340. I have annexed the order of CMP 340 of 2013 as a restriction at page 20.
This is the first something report. Where is the award prepared by the court?
Award is at page 16.
Page?
16. Decree.
The decree of the trial court. Decree of the trial court.
The trial court records
Award of the trial court.
award was not prepared in this case. Reference case was dismissed. Thereafter we prepared
So reference case was dismissed.
Yes.
Yes, what do you say, respondent? You want to file a counter affidavit to this? You file a counter. That would be better. CMP number
Same at serial
17.
17.
दोनों में काउंटर करेंगे. CMP number 1209 of 25 with confusion.
279.
With CMP number
279.
279 of
2026.
2026. आप ही हैं दोनों में? The learned counsel for the state is directed to seek instructions and file a counter affidavit in these cases. The petitioner is seeking modification of the judgment passed by this court in as much as so as to include the statutory interest in the award amount. Post on 12th of June. The counter affidavit should be filed latest by 8th of June.